I think we can start. It's 10:06, at least here. So welcome everybody to the third webinar of the Young ITA Mentorship Program Speaker Series, where we will be discussing today the excuse not to perform international contracts, uncertainties in arbitration and litigation. Today's webinar actually marks the conclusion of the second edition of the mentorship program and the beginning of the third one. So this is a very special conversation today, especially in these uncertain times. These discussions are even more timely. Thank you all for joining us, and of course, thank you to the speakers for their generosity. I am thrilled and honored to introduce our two speakers for today, who need no introduction, but very briefly. Professor Garro is a professor at Columbia University and a very well-known authority in matters related to private international law, arbitration, and the law of Latin American states. Michael Fernández is an associate with Winston Strawn. Both are based in New York, but both have ample experience in international law and with litigation and arbitration in Latin America. This is a very brief introduction, but if you want to know more, of course, we will give you their contact information for any questions at the end. And the first part of this session will be a presentation by Professor Garro, and then we will open this up to questions. So if you have any questions, and we really hope that you do, please write them down in Zoom's Q&A function, and we will post them at the end. We have a lot of time allotted to this, so we really hope to have a lively debate. And with this, Professor Garro, Michael, thank you so much.
You're welcome. Thank you very much, Karina, and thank you very much, Michael, too. It's really an honor, and I'm very pleased to be participating in this program, especially because it has been sponsored by the Inter-American New York Affairs Committee of the New York City Bar, as well as the International Chamber of the Chamber of Commerce of Costa Rica. And for me, it's a pleasure to be here, especially addressing a topic that I think it is both timely and interesting in the sense that amidst all the tragedy and hardship that this pandemic has caused, one of the aspects that I find a few ones, but definitely positive, is it has raised awareness about that we all live in the same world with different laws and with different cultures and with different circumstances, but definitely all of us actually or similar problems that are faced world. So I think that the issue that has been the topic that assigned to me on the COVID-19 and its impact on contracts in general is a very important one. There's two. And the first thing I wonder was, what is the impact of such a sort of a hardship or force majeure situation caused by COVID-19 on arbitrations and on litigations? And in principle, the answer should be there shouldn't be a big difference between the two, to the extent that the duty of arbitrators is actually to comply with the parties' expectations according to the law that they have chosen or the contract. And therefore, this is not an issue about the logistics of the online arbitration proceedings, of how to actually put forward a hearing or a decision. Here, what we are talking about is actually what is the law to be applied in a situation where one of the parties raises a defense of frustration and the like, and the other party, on the contrary, stick to the terms of the contract and wants the terms of the contract to be enforced. So this is an area of substantive law, but nevertheless, I think, and hopefully by the end of the time that has been allocated to me, I'll be able to focus on the differences that you may find between arbitration and litigation if the same problem were to be raised regarding COVID-19. Just to provide then sort of a general view of the impact of the outbreak of the infection and the pandemics, I think that if we were to limit it to contracts, we would have a very limited vision of the problems that we have been raising by COVID-19. And I think that even in the United States, you can see that the problem of how to actually face the problem, what type of containment measures to take, has really put into questions situations of individual rights, the rights of the federal government, as opposed to the right of state governments and local governments in addressing the consequences of the pandemic, the role of the executive branch, as opposed to the role of Congress to really address this problem. And there are so many other areas in which, in many parts of the world, what governments decided was to invoke a so-called state of alarm, as they did in Spain, or state of siege, or state of emergency, as in many other countries, giving to the executive branch emergency powers that otherwise, generally, that branch of government will not be exercising. Well, in the area of contract law, the consequences are extremely serious too. And again, when we address the COVID-19 problems, the first thing that I think the audience would be aware, and many of you may have in mind, is related to the issues that I'm speaking to in abstract terms and in general, is what type of contract are we? And we have seen that already employment contract, the situation of COVID-19 is already very dear, with many measures being taken by governments addressing the issues of labor, construction, lease contracts, both residential and commercial, loans, consumer contracts. These areas are in the area of contracts, but I want to addressing the cross-border international type of contracts. But COVID-19 had a strong impact on domestic contracts, and we can already see that this is an emergency, an extraordinary situation, but the many actions that both at the level of local, state, and federal government have been taking all over the world. Many of these measures have been given under the name of moratorium, and that has been mostly in the most pressing areas, such as residential leasing, the prohibition to evict tenants up to a certain extent and up to a certain date, the prohibition or the postponement of periods of time that are crucial for prescription of the statute of limitations to expire, and we have seen that in many other countries. In area of consumer transactions, loans, performance of contracts of many types are already being tackled by a governmental measure that actually applies as an excuse or as a sort of a prorogation of the expiration of a period of time that otherwise, by the terms of the contract, should be different. What happens with international contracts? Well, the situation gets more complex here because, first of all, most governments have not dared to take any general measure of any type affecting commercial contracts in general, let alone international ones. What we have seen is exhortations by governments asking parties to contracts to renegotiate, to actually enter into amicable conversations in order to allocate the risks of that COVID-19 has actually brought about. And I believe and I think that in most cases, this is going to be the type of settlement that we're going to find even in international contracts. The parties to the contract getting together and trying to make an effort to see to which extent they can twist and somehow negotiate the many losses for one of the parties or the other the COVID-19 has brought about. But in many others, that will not be the situation. The contracting party is going to stick to the terms of the contract, and he is going to say that type of defense or excuse of force majeure, impracticability, so on and so forth, is just an abuse on part of the other contracting party. And I would like the terms of the contract are the contract, that's what we negotiated, and that's what I expect an arbitrator or a judge to enforce. Now, this is when we come to the problem, because what we will see is that we will not have a one-size-fits-all solution to all the COVID-19 problems impact in international contracts. And the first variable that we need to make into account would be the choice of forum, if there is one, and the choice of law. Because no matter what clause you have in the contract, and no matter how it is written, at the end of the day, if it were to be left to the decision of a court or of an arbitrator, that court of an arbitrator's duty would have to try to interpret the terms of that contract in the first place and to apply it in light of whatever law the parties have chosen. So I think that I will start by discriminating among international contracts the different situations we might envision. In the first place, what is it if the state is a party to a contract? That's an issue and a question that comes up immediately. And as we know, that is going to be relevant to the extent that there are thousands of bilateral investment treaties actually dealing with the negotiation or the terms of the agreement between parties, foreign investors, and state parties. And there you will see that many of these bilateral investment agreements will have some kind of clause within the BIT providing for exceptional measures to be taken by the government, measures that would have to be interpreted mostly by and large by arbitration tribunals in investment disputes. And in the absence of bilateral investment disputes discussions, there will be some kind of international law, generally known as the state of necessity, which actually will try to go to the auxiliary of the state government whose measures are actually infringe on the rights of the investor. So there will be a specific legal framework governing many of these disputes where the state is a party, whereas in those other disputes, which are between commercial companies and between private parties, which are the ones that I'm going to be addressing by and large in this presentation, they will not be governed by a BIT, neither by some kind of public international law, but they will be left either to the choice of law rules applicable by the arbitrator or by the judge, or by the choice of law but which the parties had agreed. And I think that here we start with the first question. That choice of law agreement, and even that choice of foreign agreement, would have to be determined, or that arbitration clause would have to be interpreted by someone. It could be the courts of a state, or it could be the arbitrators themselves in the first place. And there you would have that the way of approaching the interpretation of that choice of foreign clause, or that choice of law, or that choice of foreign clause, or that arbitration clause, will very much depend on what is the background of that arbitration and what is the background of that judge whose job is to determine whether or not the arbitration agreement does empower the arbitrators to decide the case. If we go to the applicable law, there we would have also variations, because there could be no law chosen by the parties in which have it in a national law or choice of law rule of the jurisdiction, if it's a court, or binding on the arbitration tribunal. If they may vary in terms of what discretion how the arbitrators have in deciding which will be the most suitable applicable law to a problem, to the international contract. And you will see there is a large menu to discuss about it, and many differences between different countries. If there are some international law applicable, and there are some international law applicable to international contracts, but very few, and limited to sales of goods, and very few other contracts. And we will discuss too what that options offers when one party actually wants to raise the defense of force majeure or the like. Now, I think there will be other distinctions to be made. And one very relevant one is whether or not the contract included a force majeure clause or whether it didn't. And on top of that, when was that contract negotiated or concluded? Was it after December 2019 when the pandemic started to be known, or after January 2020 when it was actually formally declared to be a pandemic? Or was the contract entered into and negotiated afterwards when we were aware of what the consequences of COVID-19 are? Of course, the differences are going to be outstanding depending on that. But that will not be all. We will need to distinguish between contracts with and without a force majeure clause. When the contract was concluded? Where was it concluded? Was it an Asian country where apparently the consequences of COVID-19 were known earlier than other Western countries, or where? That's going to be another question. And as if that would not be enough for me being unable to give you a general solution to other problems, I think you should bear in mind what type of contract are you talking about. Supply contract of goods, and that supply contract of goods is governed by the international institution. If it's governed by national law, there will be actions. What is the type of obligation that is being prevented? Is it the obligation of the buyer to pay, or is the obligation of the seller to deliver? Well, here the distinction may be several doctrines that go to the rescue of one of the party who's unable to perform, but very few of them will be willing to rescue the buyer who does not pay money. Most of the laws, and actually we will see in the United States, there is one important provision of Uniform Commercial Code to the rescue of one of the parties to a contract of sale, but only of the seller. Unlike most other civil law countries, actually tend to actually go into the to assist either the buyer or the seller. The UCC is very clear. It's only the situation to deliver and the time of delivery that can find an excuse in case you have an excuse. So I think that you see already that the type of contract is important, whether it's a loan, a construction contract, or a contract of sale, or that would be a big difference. What is the type of obligation also would be important. Another important question that we need to raise, the obligation, the impediment, the event, the circumstances, which may be related to the pandemic itself, or what I believe to be even more significant, the measures aimed at containing the pandemic. Those are really the type of issues that are likely to become very much litigated and arbitrated in the past, because probably the pandemic could generally have said, could have been generally foreseeable. What is unforeseeable today in today's world, but the measures, the lockdowns, the quarantines, and the extension and their duration, that is less likely to have been able to have been reasonably foreseeable by the parties to a contract that enter into a contract before December 2019. So I think that's an important one. The other question that we need to consider, before I go into the questions of doctrines and theories, well, if there is a force majeure clause, that clause would be crucial. But that clause would have to be interpreted by someone, be an arbitrator or by a judge under a certain applicable law. And definitely whether you apply the parole evidence rule or the four corners rule or those type of rules that English and American lawyers are very much used to, that you are supposed to find the meaning of the contract within those four corners, would be opposed to civil law judges or arbitrators who would be able to consider, unless the contract provides otherwise, any circumstances during the negotiation and after the performance of the contract to understand what the parties meant and what was their intention. So a force majeure clause, no matter how it was drafted and how it was drafted, is crucial. But no matter how it was drafted, when it will be interpreted by an arbitrator or a judge, and the law applicable to the interpretation of that clause will also be important. The other important point that I think, and I guess is the last mention among the variables to take into account, is the background, the cultural legal background of that arbitrator or that judge. Because if the contract is between parties actually located in different countries, the job of the arbitrator or the judge is actually meet the expectation of the parties. The expectation as expressed in the contract, of course, but the contract is going to leave many gaps and ambiguities. So it is important whether that arbitrator or that judge is someone experienced with international transactions, because he or she may be able to understand that the expectations of the parties may be of a different type depending on their culture and location. So what are we left with? And these are the few last minutes that I have for my presentation. What is there as theories, as doctrines, as someone put it, non-contractual impediment doctrines, meaning if their contract doesn't provide for these kinds of extraordinary events, what type of remedies, what type of law can the arbitrators or the judges apply? Well, in the first place, of course, would be the one that the parties chose, but you should remember that even in that case, there is much leeway to be explored, especially in arbitration, when many arbitration laws actually give the arbitrators the discretion to apply the conflicts of law rules that they deem applicable. And even some other arbitration laws, most modern arbitration laws, I would say, started by France, Mexico, they actually give the arbitrator the power to apply the law that they find considered most suitable and most fitting the problem at hand. So I think that there is a lot of work to be done by the arbitrators, and there is many choices out there. But among those choices is the fact that they have to apply either the local law or the foreign law, which the parties have chosen. And in that sense, what diversity are you going to find? Many. There are common grounds. One, impossibility. Even the common law, which has been, as a result of the doctrine of consideration, really very reticent to admit excuses for non-performance. Even the common law court today widely, I mean, physical or legal impossibility to perform. But I mean outright impossibility, not more difficult, outright impossibility. In those cases, the parties exonerate to perform. And there is no difference between civil law and common law. Of course, the wording of the Swiss civil law and the German code, as opposed to what the doctrine of impossibility in some 18th century English case, may be different, but the gist is the same. If you are ever able to establish, that would be a cause for exemption. Another area where you will find no differences regardless of the legal tradition, the burden of proof. It is the party who obviously raises or alleges with the proof. Now, other than that, we'll see enormous differences. Starting by the fact that already in the 19th century, the common law had to start thinking that even if the case was not actually absolutely impossible to perform, there are some cases that would be unreasonable to force the parties to perform the contract. So the English courts started in very famous cases dealing with the closing of the Suez Canal or some coronation cases in the early 1900s with this idea of frustration of contract. Frustration of purpose, which actually came out as part of the US law of the common law of contracts and is accepted by the restatement of contracts in the United States and by every state of the United States. The civil law never spoke in terms of frustration, but also had to speak in terms of other type of doctrine to actually meet those cases in which the change of circumstances was so radical that the type of contract that the parties faced is completely different than the one they had originally concluded. And what you would find in most civil law countries is a doctrine of force majeure. But be aware, for an American or an English lawyer, the word force majeure is only connected to a clause in a contract. They don't understand anything but a force majeure clause or a hardship clause. Well, that's not the case in the civil law. Since the Roman times, there was idea that the force majeure is impossibility to perform, but under specific terms, which already the French civil code, the Napoleon Code, articulated in its code, and it has been replicated in many other, if not most other civil law systems. Not all of them, but most of them will have some definition of what force majeure, which would include of that excuse, which would be unforeseeability, inevitability, insurmountability, unavoidability, and that the event definitely has to be external, without, beyond the sphere of control at top of the fence. You will common trends in most civil law countries, not in all, I repeat, but in most. And they don't speak with one word, these civil law countries, because as of 30, 40 years ago, the law has started to be changed in many countries, starting already, if I go with them, so-called modern civil codes in the civil law. And already that Italian civil code incorporated another doctrine other than force majeure. One would expect it to meet the situation where it was not impossible. That was actually the meaning of force majeure. It was not impossible to perform, but it was extraordinarily, unreasonably harsh to force a party to perform. In which case, they came out with another doctrine, which in different countries and different languages take different names, but which modern law, and by modern law I mean the most soft law instruments that attempt to harmonize contract law, they call it the hardship doctrine, which has nothing to do probably with the hardship clause notion that you had in English law or in American law, but it tries to evoke the situation, what is an economic impediment, but an economic impediment of such a nature that the change of circumstances has been so radical that the performance of the parties become extraordinary or onerous. What is extraordinary and when it really surpasses that threshold of unreasonableness, of course, is left to the discretion of judges and arbitrators, but that is a tool that you will find in most these instruments. So you would have today, in most the force majeure clause, but at the same time, you would have the possibility of entering into some kind of hardship doctrine, which may be articulated in different ways in different countries, but it really doesn't speak any longer in terms of something was unforeseeable or unavoidable. What they talk about is whether or not that change of circumstances was reasonable to have been taking them into account at the time the contract was concluded. So the terms are a little bit more flexible, and they don't speak in terms of that completely unavoidable or insurmountable, or whether or not the event reasonable beyond the control or outside the sphere of control or the sphere of risk of one of the contracting parties, in which case, and only in that case, the party can raise the hardship doctrine or the force majeure doctrine. I have distributed among you the text, many of these texts I'm talking about. I'm not going to lose my time actually trying to go now to the share screen and move it to you to see how those doctrines are articulated nowadays. But I think it's important law countries, especially modern amendments to the civil codes, including the French Civil Code, which for the first time introduced not only a refurbished articulation of what force majeure means, but also has another article explaining what hardship is and when hardship can be used as an excuse. Whether or not French courts will ever use this, it remains to be seen, because there is no, not to my knowledge, doctrine of hardship yet that I know applied by French courts. But it should be parties should be aware that French courts for more than a century were always reluctant to apply any type of hardship doctrine on situations like similar to COVID-19. What will happen now? It remains to be seen, but I think it's important, and with this I will be wrapping up, that whatever the civil codes say about force majeure or hardship, it's always waivable. The parties can always opt out. It's not a question of public policy here. If it's a commercial contract and the parties have been well informed and well advised, of course the parties can exclude and can amend or change whatever type of risk the contract arises. So it was very common, and that's why it is extremely advisable for the parties to draft very carefully a force majeure clause or a hardship clause. Of course, today, with the awareness of what are the consequences of the pandemic, but it would have been ideally to have had that type of force majeure clauses drafted, taking into account this type of pandemics as some kind of an act of God or act of nature that actually disrupts the performance of the contract. I distributed among you the forms or the formats of the model clauses that the ICC distributed in March of 2020. Just envisioning the situation of force majeure or the situation of hardship, you will see that there are differences between the two. But what I think the differences are most relevant is in the question of remedies. What happens if you really meet the requirements that the event has really been, or the impediment has actually been so harsh as to justify some kind of excuse under force majeure or doctrine? Well, on there you have a panoply of possibilities. Civil law countries have been, by and large, more in favor of giving the judges or the arbitrators, if arbitrators, and not because of an ex aequo et bono clause, part of the applicable law, under the applicable law, giving judges or arbitrator the possibility to adjust, revise, adapt the contract of the to the change of circumstances. That is not something that any common law court would be amenable or willing to do under common law notions, where judges are not supposed to do the contract on behalf of the parties. But it's interesting how even civil law courts don't speak with the same voice. In some countries, as the case of Italy, the party affected by the impediment, the only thing he can do is to ask for termination. Only if the other party comes back with some equitable readjustment as proposal, then only in that case the judge under Italian law can actually adjust the contract. That's not the modern solution that we find in the unit of principles now, which depart from the principle that the contract, no matter how harsh, has to be performed. If it is an extraordinary situation, then in that case, one party may raise the issue of hardship. And what is the remedy in hardship? What the unit of principles say is that the party is entitled to request renegotiation. And be aware of this. many people have criticized this because I've said, how can you establish a duty on the parties to renegotiate? That's not what the unilateral principle says. It's not a duty to renegotiate. It's that a party can request the other to renegotiate on the basis of some kind of good faith adjustment that would allow the parties to reach an amicable settlement. But this is not what I've seen in the French version of which even though modeled under the unilateral principles, the French provision on hardship actually seems to impose a duty to renegotiate. What would be the consequences of not renegotiating or not renegotiating in good faith? Well, probably the arbitrator or the judge may send the parties back to the negotiating table if the judge or the arbitrator finds that there's another solution. But I think it's important to see that renegotiation should not be regarded generally as anything but a duty to good faith to try to reconcile, to find a middle point in the situation. But if the renegotiations fail, and within a reasonable time, the parties do not reach a negotiation, the unilateral principles, as well as the French new version of French Civil Code, and many versions of the Argentine Civil Code of 2015, also, they give the judge or the arbitrator who operates under that rule the power to adjust the terms of the contract, to have it terminated as of the date when the arbitrator or the judge considers that should be adjusted, or to adjust the terms of the contract. Generally, you should expect that judges or arbitrators will be extremely reluctant to do that, will probably try to encourage the parties to reach whatever. But again, and with this point, I will finish just to give you time for questions and comments. It's interesting to see how civil law countries do not speak even on this issue on the same voice. If you look at the case law of the German Civil Code, under just the principle of good faith, in the early 19th century, developed a whole theory of hardship, just on the basis that in some extraordinary circumstances, unreasonable to force the parties to perform a contract as written. I'm talking about the hyperinflation cases of pre-war Germany. Only in those, the German judges were stick to the point and said, if the contract has been adjusted, we will adjust the contract. Termination is the last resort. Whereas in other civil law countries, you will see that termination is the privileged remedy. The parties, if they are unable to actually reach an agreement, the only thing that the court of the arbitrators do, terminate the contract, the parties return whatever they have been given to each other on the basis of principles of unjust enrichment or whatever, but there is no possibility for the judges or arbitrators to adjust it. There's one final, probably, tool the arbitrators have, which is the possibility that under most arbitration laws parties have to give the arbitrators the power to decide the case ex aequo et bono on the basis of equitable principles. But in major arbitration cases, this kind of powers, the parties will be very reluctant to give to the arbitrators. But this is something that you should be considered because after all, there's no one size fits all for these kinds of problems. I think that at this point, I will stop just to trying to give you some sort of a panoply of different types of remedies and doctrines and clauses and problems that you may face, with only one final point. Whatever your situation you find yourself, if there is a situation of hardship where your client thinks that he can actually raise that defense, do not forget basically to comply with two duties that almost universally are required. The first one is to mitigate. No court or arbitrator will give you the possibility of getting out of the contract without making sure that you did everything possible to actually mitigate the problems of the hardship of the measures enacted as a result of COVID-19. So this is basic. The second one, if after exhaustive mitigation remedies, you still think that you cannot comply under the terms of the contract, you should give notice. Give notice about what is the impact of the containment measures in the performance of the contract, why you cannot meet that sort of standard, and what type of remedy or for how long it will be, because this is another very important issue. No doctrine of force majeure or hardship will give you any relief except as long as the measures are in force. Since we are all expecting the pandemic's consequences to disappear, but we still don't know when, and it has been taking a long time, the problem here is that the duration, the extraordinary duration of the lockout and the quarantine measures that have been taken may turn temporary non-performance in permanent non-performance. So one party may as a result of that extraordinary duration, consider that after a certain number of days, that temporary impediment has become permanent. This is something important that you should include in your notice whenever you want to invoke any of these doctrines. With this, I'm going to stop here, Karima, and of course, I'll be happy to respond to any questions that you may have. Thank you.
Thank you, Professor. We have a couple of questions from the audience. The first one is, what type of force majeure disputes do you see being referred to arbitration more since COVID?
Well, that question points into a question, what would be ideal type of dispute resolution mechanism for situations that are dealing with this, with COVID-19? Well, definitely I would think that, again, before I give you the very frustrating response, it depends on what kind of contract you have, what type of obligation is, and so on and so forth. I will tell you that no matter what type of contract you have, probably you would benefit if you have some sort of a multiple step dispute resolution clause where you at least try to get some mediator, and if this is international, and you have a supply chain contract with a Chinese supplier going to a French supplier and then to another third party in another country, then you may have a lot of laws being applicable here, potential laws of applicable. So I think a mediator who actually has some sort of a general cosmopolitan cultural background on the laws of the different countries, that would be even, or the cultures of the different countries, that even more helpful. But mediation or conciliation, as we all know, has a time limit, expiration time. So if after 60 days or 30 or 40 or whatever you put in your clause, the dispute has not been settled, then probably you'll be better off with arbitration or litigation. Why is that so? Because with arbitration, as we all know, have more possibilities, more choices. And arbitrators themselves have the possibility of not limiting their choices to the applicable national law to the contract to apply. They may choose among many soft laws instruments that today are in place that are extremely helpful and that give the arbitrators the tools that he or she may need to give a good solution. Therefore, I said, mediation, arbitration clause, that would be ideal. If at the end of the day, you end up in a court of law, I wish would be some court of law which will be staffed by some judges who are experienced in international transactions and knowing and aware that these cases are not decided necessarily the same way that the Court of Appeals of London or the New York Second Circuit will decide. There are many different courts in the world and solutions beyond those, such as the Second Circuit in New York or the Court of Appeals of London may apply, or Geneva.
Thank you. Michael, we can go ahead with some of your questions and then come back to the audience's questions.
Absolutely. So, and thank you, Professor Garro, for that very interesting overview of kind of the different rules operating in civil law versus common law jurisdictions. One thing I want to start off, and I'm going to this will roll into a couple of hypotheticals, but here in the United States, generally, foreseeability plays an important role in determining the applicability of an impossibility defense, right, or even a force majeure clause. Because if you could foresee the risk, then you should not be entitled to these types of protections, right? So the question I have is, are there differences in the way that foreseeability works in a civil law jurisdiction versus, generally speaking, and I understand that there will be differences, but generally speaking, in the civil law world?
Thank you for the question. I think it's important because my presentation was mostly aimed at providing you what are the tools that are going to be in the hands of arbitrators and judges facing these problems. If the question were to be, do you think that under those tools, the outcome, the actual outcome of the cases will be different depending on whether you do in this country or the other? That's a bit more doubtful of that. Why? Because in the first place, I do think that most arbitrators or judges, no matter where they are, they're going to be extremely reluctant to depart from the terms of the contract. They will find that, of course, their basic duty is to actually enforce the terms of the contract as written. But also, there is a standard of reasonableness that I think bears in the mind of an arbitrator sitting in Beijing as much as an arbitrator sitting in Paris or in New York. And in that sense, Michael, what I would say is that you shouldn't expect beyond the terms of the contract, beyond the applicable law, not much differences among the different arbitrators or judges who are going to handle this, because they're all going to be under the pressure of having to enforce the contract as written, but also under the pressure of seeing that if COVID-19, and I agree, you emphasize the word unforeseeability. And I said, I think that the word unforeseeability as such is a little bit absolute. And I wonder, what is unforeseeable today? Very few things. Even a pandemics, we have suffered epidemics, infections, outbreaks of infections in the world before, and there is case law on these types of situations before. And you have seen courts have gone different ways, but many courts have said, well, an epidemic of this nature was foreseeable, etc. The question here is whether the effects or the consequences of COVID-19 were actually expected by parties who concluded a contract as of a certain date and in a certain. That is a more pressing question. And I can tell you that the COVID-19 is the consequence of COVID-19 can hardly be foreseeable for many parties who actually enter into a contract before the pandemics came into being or the lockdown measures came into being.
So in that connection, I want to walk you through a couple of hypotheticals at different periods of time to see how maybe there might be, whether there would be differences between kind of civil law arbitrators and common law arbitrators. And I think the easiest scenario to start off with is, let's suppose the contract was negotiated and everything was set up a year before COVID struck, right? Before we even heard about COVID. Under such scenario, and let's say then there are issues with the party's ability to perform, and they want to invoke force majeure or impossibility or whatnot. Would you expect there to be any significant differences between how a civil law arbitrator would approach that versus a common law? My intuition would be that they would both kind of look at it as a good case for potentially applying force majeure depending on all other facts, but there wouldn't be this issue with foreseeability in play.
I think that to say that there will be no difference would be to going too far. Let me tell you why I think that the differences could be relevant. In the first place, assume that it's a New York court or a New York, or it's an arbitration sitting in New York, which needs to be decided in New York law. I think that the first question that a New York law question of force majeure will raise is there a clause in the contract? And actually, would be uncommon for a New York court to apply a force majeure clause, a force majeure doctrine in the absence of a force majeure clause. That will not happen if the applicable law would be the law of a typical civil law country where doctrines of force majeure as such were already in place for a long time. Whether or not they will reach different results a different way, but I think they will think differently because, as I said, for a New York lawyer and a New York law, force majeure has meaning only under a certain clause. And the interpretation of the clause would be also maybe subject to, look, if the contract is subject to New York law, no matter if it's an arbitrator or a judge wants to apply, the Court of Appeals of New York has a very versus central market that is very much often cited. And in that very important precedent in New York State, the court said that unless a majeure event is expressly anticipated in the clause, then force majeure will not be an excuse. That's a very tough in contract. A contract is always a contract, but that's a way of thinking about New York doctrines of force majeure. The court will look at where there is a clause. If there is such a clause, will construe it very narrowly, strictly, and then only then it will go to see what type of exception or remedies are. I think that the way a civil law court will do it is will consider it irrespective of whether, if there is a clause, of course the clause would have to prevail, but in the absence of such clause, they have 100 years of jurisprudence and doctrine developing these ideas of impossibility or hardship performance. That will make a difference.
So to summarize that, and maybe tell me if this is not a correct statement, but basically it seems like generally if you're a party and you're interested in invoking force majeure, you're likelier to be able to do so with a civil law arbitrator versus a common law kind of New York arbitrator. Is that a fair statement, you think?
I think that the first statement is that the difference in the outcome may be whether or not the New York arbitrator has been schooled and has some awareness that not everywhere else in the world they decide things like in New York, that there are other doctrines and there are other ways of going about it, which is a problem we have also in courts, of course. But in the arbitration is more important because generally arbitrators are chosen within the expertise. If the case is international, it includes whether or not they have an understanding that these issues are decided or looked upon differently in different parts of the world.
So let me ask this kind of in sticking more now to the civil law world versus the common law world, and now let's talk about a situation where the negotiations were taking place while COVID was spreading in Asia, but it hadn't reached those particular jurisdictions, right? Like, so you kind of had this vague awareness that there's a pandemic somewhere else, but it hasn't reached your shores. What do you think that, you know, I presume that that's a harder case to establish force majeure than kind of the first example we talked about, which was nobody had heard anything about it. But do you think it's a significantly more difficult burden to carry under the, you know, in those cases, generally speaking, to meet your burden of establishing force majeure if it hasn't reached your jurisdiction? Or can we expect that courts will generally, in civil law jurisdictions and arbitrators, will generally still look upon those claims favorably?
I think that the arbitrators and judges are going to look upon this issue when the contract concluded, and whether at the time the court, the parties, not only whether they did, whether should have been aware there was a possibility of this type of outbreak, the outbreak of the infection, and how that could affect their contract. Why do I say that? Not necessarily notion of foreseeability or unforeseeability be different, but there's one important element underlying all these contracts, which is a question of allocation of risk. Same way that a New York judge may, or an English judge may think that if the contract did not provide a force majeure clause, is because it is assumed their shoulders the risk that something could happen like this. Well, in the same way, a judge or an arbitrator is going to think about, well, should the parties have been aware that this type of event of outbreak of an infection could affect their contracts? If so, why didn't they include a clause providing for this situation? And the court may well conclude, or the arbitrator, that if they didn't, is because the parties were aware, and one of the parties is, of course, is going to argue one thing and the other one the opposite. And the arbitrator is going to say, well, in that case, I assume that the parties were aware and assumed the risk. That's why, Michael, I think that the timing of the negotiation and the conclusion is relevant to the application of force majeure clause because of that question of assumption of risk.
So on the assumption of risk, let me pose one last final hypothetical. Let's say that I have a colleague in my corporate group that's negotiating a deal today, and they're closing it today, and they're trying to figure out which law to apply, civil law or New York law. At this point, we kind of know that COVID is generally risk, but we have some gauge that potentially there could be a second wave in various jurisdictions. At that point, is there any difference in terms of which law you pick, whether one will be more beneficial if you potentially want to later on invoke force majeure? Will there be any difference, or under both circumstances, are you basically going to get very similar outcomes, which is probably going to be the tribunal saying, this is foreseeable, you should have, what are you talking about?
It's a very interesting question. I think that my first part of the answer to the question is, it depends on which side are you, of course, because if you're the party affected by the event, by the COVID-19, probably you would prefer to be in a forum and under a law which actually provides you as many possibilities or panoply of remedies as possible to be able to get out of the contract or to mitigate the hardship effects of the contract, than in a common law jurisdiction where there is no history other than frustration of contracts. And very recently, the Uniform Commercial Code section 2615, with its no by American courts in commercial cases. And I think that this is, I think, the important, which side are you in? It reminds you of a very interesting question once after a very exhaustive comparative discussion of criminal procedure in the various civil law countries and in the United States. One famous comparative law professor in Cornell Law School was asked, what system do you think is preferable? The system of prosecution that you have in the American way of procedure, or the one in the civil law system? And his answer, he says, if I were guilty, I would prefer the American. I would prefer the American system. If I were innocent, I would prefer the and I think that on these issues, really, it depends on what side you are, because I believe that if you were to be in a situation where you are the one to invoke the hardship events of COVID-19, you would probably be better off with an arbitrator who is well versed in different legal systems, which operates under applicable law that provides more than one. And look at the UNIDROIT principles or the French Civil Code, or the Argentine perhaps Civil Code recently adopted. They have one provision of force majeure and one provision of hardship. And you see, but Jesus, the facts are the same. Well, in that case, you're the plaintiff, or you're the one who is seeking relief. You choose. What one do you think is better? The remedy and the hardship provision, or the remedy provided under the force majeure clause? And the ICC in March 2020 did exactly the same thing. Well, they did it before that. They adopted two different ICC clauses. One is the force majeure clause, and the other they put it a hardship clause. You will see that in many aspects, the unforeseeability, the unavoidability, etc., mitigation, duty of notice, they're the same, but there is a difference in the remedies. In the situation of hardship, Michael, and I think this is an important point for parties to think about when they decide to go to arbitration. There are clauses which give the adjudicator, be a judge or an arbitrator, the power to adapt, readjust the performance of the parties if the parties are unable to do it on their own. There is no tradition of courts doing this in the United States or in England. There is tradition in courts doing that because they have 100 years of legal scholarship and case law on precisely this issue. So I think that if you're in the position of seeing that your client has one of these problems, I would very much favor having that type of legal system, such as the UNIDROIT principles, that give you more than one possibility and give the judges a panoply of different remedies.
Perfect. And that's a good segue for one of the audience questions that we had, and we would encourage more members of the audience to ask any questions they may have. But the question from a member of the audience is, under what circumstances can a party with a payment obligation, the buyer, be relieved of that obligation under force majeure? And you mentioned that earlier, so the speaker wanted the audience member wanted to follow up on that point.
Yeah, I think, and I wanted to mention that in many of the jurisdictions, and talking about the civil law jurisdiction, which have a quite generous and rich scholarship on this, in Latin known as a clausula rebus sic stantibus, which actually is an invention of canonic law, the law of the church, saying that a contract is always a contract as long as the circumstances and the basic assumptions existing at the time of its conclusion remain at the time of its performance. That doctrine, which has been received by recent legislation in civil law countries, generally provides that the change of circumstances may lead to a readjustment or termination of the contract, but generally they do make a distinction between whether the performance is a payment of money or the performance of an obligation to give money, or an obligation to do or not to do, or some kind of performance which requires a performance in kind. Because what I've seen, and this is very clear in the scholarship and in the case law, that it would be very harsh, not inconceivable. Let me make clear, not inconceivable, but very difficult for a buyer to claim excessive onerousness, or whatever term they use in the country, excessive hardship, to be able to get out of the contract. That he cannot count for the money. And that's what an arbitrator or a judge is likely to say. I'm not saying that in cases of extreme unreasonableness, an arbitrator or a judge, under the law that I'm talking, may be forced to say, that pound of flesh you cannot get. It's too much. We will make some kind of readjustment. But again, this is going to be exceptional.
Got it. And one question, kind of, you mentioned earlier that one of the things that you should generally do, irrespective of your jurisdiction, is mitigate. I guess one of the questions I had is, how does that duty to mitigate in your mind differ between, or does it differ between civil law versus common law jurisdictions?
I think it's an interesting question, and perhaps your experience in your law practice may have, with civil law jurisdiction, may have prompted you to raise that question, because duty to mitigate, if you ask a civil lawyer about the duty to mitigate, he or she may be at a loss at the beginning with the word mitigation, probably, which has not gained the force that it has legally in the United States or in common law countries. And that's because very few civil codes of the 19th century actually received the word mitigation as such. But you will see, Michael, and that's why my answer to your question is that the difference should not be too big between civil law and common law. But as you know, civil law countries also are very much used to another concept that common law is frowned upon, which is good faith. And that, I think, again, has a sort of ambiguity and vagueness. Well, but a part of the duty to negotiate, form, and perform a contract in good faith is that once there is a breach, the party aggrieved by the breach, the non-breaching party, cannot sit down or cross his arms and do nothing about it. He or she has the effort to do everything is possible to reduce the loss, to mitigate. Now, this may not be expressly stated in the civil law countries, Michael, but it is implied in the duty of good faith, and many jurisdictions in the civil law have recognized that the duty to mitigate, even if not recognized as such expressly in the code, it's part of the duty of good faith. That's why my answer would be, it shouldn't really make a difference. And in a situation of hardship, the arbitrator or the judge is going to expect that the party who suffered a loss as a consequence of the measures taken to contain the infection did whatever he could. Like, for instance, law schools given Zoom classes. I mean, you're going to say, well, am I giving my side of the bargain? I paid for my tuition for having real classes, and here I'm a Gavin professor giving me a Zoom class. Well, what else could the law schools have done? And you're going to be measured by that. Could you do something? Was that enough? Well, that's another question. Whether or not, under the circumstances, you took whatever measures you could have taken. Look about the restaurants now, under very serious situations. What I expect arbitrators and judges to say, did you have the possibility of delivery orders and to serve, customers by that way? Well, that's a possibility of mitigating your losses. You cannot sit down and say, my restaurant was closed, I cannot pay the lease. So these are many circumstances, tough calls, but in which arbitrators and judges are going to have to consider.
Thank you. That's actually fascinating. And we have one more question from the audience. They're asking, any interim relief available in arbitration or litigation, keeping in mind that force majeure claims take a while to be settled in courts or in tribunals?
Okay, so if I understood the question correctly, the question addresses the issue interim relief. And that, of course, is crucial for every lawyer, because as soon as you receive that situation, the first question the lawyer should do is, what can I do now? Not until the end of the day after the trial and a judgment. And my answer is yes, of course. Of course, it will depend on the jurisdiction and the arbitration rules, whether they would have whether an emergency arbitrator in place or some kind of interim relief in place, and you would have to fulfill the requirements of those arbitration rules to actually obtain that relief. But there are going to be common sense requirements which go around the question of likelihood to succeed on the merits, the kind of balancing of hardships, and that sort of elements that the arbitrators and the judge will take into account. But definitely you should be able to go to interim relief be aware of only one thing. And again, I don't use the share screen, although why wouldn't I? Because I think that would be important to, if I can call the attention to the reader, to the audience, to the provisions of the UNIDROIT principles. Let me see if I can find it here and locate it for you. I think it's important to read all the rules of on hardship and look at the first rule, and that's why I think it's important, the question. Where the performance of a contract becomes more onerous for one of the parties, that party is nevertheless bound to perform its obligations subject to the following provisions. So the provisions of hardship follow, but the first provision is no matter how harsh the situation is, you have to continue to perform. Of course, if you meet the requirements of Article 6.2.2, and there are tough requirements from A to D, but you mean, then in that case, what the remedy section 6.2.3 gives you is the possibility to request renegotiations and to do it without undue delay. But look at paragraph 2 of Article 6.2.3, which is the one I want to bring to the attention of the party who asked me that question. The request for renegotiation does not in itself entitle the disadvantaged party to withhold performance. So be aware of that situation, and I think it's important that you, of course, can request interim relief. You can always show that you meet the requirements of interim relief, but don't stop performing, because even the most flexible provisions like the UNIDROIT principles say that requesting renegotiation does not entitle you to stop performing. You can stop performing if the tribunal were to allow you to stop things and see what would happen next. But I think it would be imprudent to stop performing immediately.
One follow-up question on that, Professor, and basically just looking at that standard in and of itself, it seems like a party that is going to seek interim relief basically better be very prepared to argue that it has an overwhelming likelihood of success on the merits. That's how we would think of it in the United States, right? We tend to think of it in that perspective. And that therefore the interim relief request is almost like you're seeking, you would end up basically be seeking the arbitrator or the judge to take a position on the ultimate success of your case at that point. So just, I don't know if that makes sense to you, and whether you have any thoughts in terms of potential ways that a party could prepare to kind of meet that burden in advance.
Well, I think it's important. The focus of your question is what are the standards for likely to succeed on the merits, what the Romans call the fumus juris bonis juris, the smoke of good law, whether you have the possibility of winning the case. Of course, the arbitrator will make it very clear, and that's why it's very tough to be an emergency arbitrator, because you haven't heard the parties yet, you haven't heard the evidence, and you're being asked to take a tough measure. I would tell you that the question is how strong your testimony is going to, your expert testimony is going to be, or how convincing is the case you have, that you might, at the end of the day, win the case. The second question is that would have to be also complemented with what American lawyers call the balance of hardships. What would be the hardships for the party invoking the request as opposed to the hardship for the party actually suffering that request? That would also have to be taken into account together with the likeliness to succeed on the merit. And finally, Michael, I think that even though the call would be very tough to make for an emergency arbitrator or for any arbitrator or a judge, at the end of the day, you can always request a bond, a performance bond, to actually make sure that the other party make and deposit the amount of damages that will be granted to the party if the relief would have been unwarranted at that stage of the litigation or the arbitration.
At an earlier point, you mentioned the state, and I think this is always on the minds of everyone in Latin America, because usually the state tends to be a counterparty to a lot of contracts here. Do you expect that there will be significant variations in terms of arbitration outcomes where the state is a party in these arbitrations?
I do, and that's why at the beginning of the presentation, that the problems that we are discussing at the level of investment arbitration, when you have a national one state having a contract or a concession agreement or anything that investment in another contract, which is also a party to some kind of international treaty, such as the ICSID Convention. And on top of that, they're also for the rights of the investors for the investment. I do think that it makes a difference. If you have a BIT in force and the arbitrator has to decide on the basis of the BIT, because in the absence of the BIT provisions, and I said before, there are most of the BITs have some kind of emergency rules granting some leeway on part of the state party to comply, to perform with the contract. But even in the absence of that, you have public international law provisions, including the right of the state of necessity under the draft articles of the International Law Commission, which give the state some kind of grounds to defend itself in cases of proven extreme urgency. Now, what if you don't have any of those possibilities? The state, would presumably the state has actually entered into its commercial private law capacity. And as we know, as you mentioned, many companies in Latin America, regardless of whether it's oil, gas, or mining, or any other companies, they do enter into the market under the assumption they are working as in par and in an equal situation with another commercial party. Even in those cases, I think it's important to take into account, because as you will know, in Latin America, we have this notion of so-called administrative contract, whereby even though the state enters into a contract in which the state is bound to perform the contract, specific performance against the state would be unusual, because the state has the privilege of actually paying damages instead of specific performance. That's one of the elements. And secondly, interim relief, if that would mean the interruption of public service, you also would face many administrative law provisions, which are public order provisions, of which the arbitrators cannot be absent to, which are going to be binding on the arbitration tribunal, and that therefore should be considered. In one word, the presence of the state will make a difference. And I guess, you know, when you enter negotiations with a party that is part of the central administration of the state, or even completely autonomous, you're still going to have some issues that are going to be different than a private versus private dispute.
So let me kind of looking forward, and this is kind of be asking you more to use a crystal ball to gaze into the future and try to maybe make some predictions. But to the extent that this crisis keeps harming global economies, I mean, in the United States, it's took a giant bite out of our GDP last year. And Argentina has been very hard hit, and most, pretty much anywhere you go, you're talking about contractions of 10, 15, 20%, companies having a lot of issues in terms of being able to make payments or, move goods because of quarantines and everything. Do you expect there to be, at the level of jurisprudence, right, any kind of evolutions in terms of how courts in particular look at these various doctrines, maybe with an eye towards making them more favorable towards parties seeking to invoke them? Or do you think that there's probably like the likelihoods that that's not going to be a major issue going forward?
What I expect, unfortunately, is to be a wave of arbitrations and litigations bringing up these issues in international contracts, and we will having filter through the years to come a jurisprudence and a case law and arbitration awards that are going to be discussing this type of doctrines we're discussing at this point. What I do expect also is that the judges and arbitrators will become more familiar with the difference in terminology that we're using, regardless of whether it's frustration or impossibility or force majeure or hardship or impracticability. The arbitrators are people familiar with international contract, have become more familiar with this concept. What is difficult to predict is that the courts or arbitrators are going to be less rigorous than they have been in the past. And why? Because most courts and arbitrators are aware that whatever they decide is going to have consequences for the future. So if you see that the international contract or dispute that is at stake is one which, once it's decided, is going to have an impact on many other contracts in the future or together, then I think that the arbitrators and judges are going to be much to actually be more amenable to give an equitable, flexible solution, because they know that as soon as they depart from servanda, from the contracts ought to be performed as written, principle dogma, they would allow a lot of many litigation. So I don't think, Michael, that there would be something less rigorous standards, but I do think they will become more familiar with it, and that more of these doctrines will be applied as opposed to the future, because the consequences, the economic and social consequences, are very serious than the ones we are already facing.
So we have one last question from the audience. If you have any experience in English law, can you comment on comparison on interpretation of force majeure principles under New York law and English law?
To the extent that I've been exposed and discussed with my colleagues about this issue, my experience in that sense is limited, but enough to be able to tell you your in England as force majeure is a concept not attached to any doctrine, but to a clause, contractual clauses. So that's in the first place. In the second place, interpretation that generally is strict and narrow to those exemptions given under force majeure clauses. And finally, I think that even between England and the United States, they don't speak with the same voice, because England continues to go with as the only, other than impossibility of performance, the only doctrine that English knows is frustration of contracts. And that's the only, and frustration of contracts, again, goes back to the coronation cases of the early 1900s. There have been more recent decisions rarely applied it, but when they have applied it, English law has statutory provisions for us go back as providing for the type of restitution remedies and unjust enrichment remedies that the parties can do. In the United States, I don't know of a statutory contract doctrine at all, but I know that the restatement of contracts has extremely flexible provisions on frustration of purpose, and that the UCC section 2615 also provides only for contracts of sales and only in favor of the seller's failure to deliver or for the seller's failure to deliver on time. Only those excuses, very limited, if you can establish that the assumptions that the parties made at the time of the contract were assumptions which were absolutely basic to the performance of the contract, and those assumptions radically change at the time of performance, then in that case, and only in that case, the impracticability remedy may come into play. That's as far as I go. But again, there is not much of a rich literature on the issue of granting this type of remedies in favor of the party who has been aggrieved by the hardship.
I'll ask one final question, kind of jumping off of that question, which is, and it ties to the earlier question I asked about kind of evolutions in kind of jurisprudential views on these issues. You know, the longer the crisis wears on, can we expect potentially to see maybe a little more convergence between common law systems that are more strictly thought of these defenses as generally contractual type defenses and not non-contractual defenses, and the civil law systems that kind of look at this in a more different light, and even kind of in light of the clausula rebus sic stantibus, and maybe a more convergence there in terms of just practical outcomes and how these cases are dealt with?
I think that the consequences and the prolongation of the consequences that we're living through the pandemic is going to force lawyers and, of course, eventually arbitrators and judges to think more thoroughly about these issues. I think also that they are going to be acquainted with many other different ways of going around these issues that we have been discussing today. Whether or not, Michael, this is going to, in the end, lead to the convergence of doctrines of around impossibility of performance on the common law and the civil law, that we would have to many ways for many years to come to decide whether that would be the case. I think that the legal systems will continue to speak in their own language, with their own doctrines, with their own legal doctrines on the same issues. they probably realize, and I think that's the most benefit of this pandemic, at the end of the day, knowing that the problems are very similar and that the solutions also should be similar, no matter what is the law that you apply in these cases.
That's it for me. I think that's a good way of finishing off.
Definitely. Thank you so much. Thank you, Michael. Thank you, Professor Garro. This was a fascinating and so timely conversation. Thank you all for joining us. And well, we have great comments from our participants. So congratulations to both of you, and hope you join us for the next edition of the speaker series. So everybody be safe. Thank you. Bye-bye.
Thank you very much, and goodbye to you. Thank you.